Good afternoon, everyone, and thank you for joining me for today's webinar, which will cover the merger of the family law courts from the 1st of September in 2021 and how the court system currently operates. It has been a huge learning curve for many practitioners who were used to the old way of doing things. However, we are all finding our way at the moment. So just a bit about me. My name's Tila Morrison, and I'm an associate at Michael Lynch Family Lawyers. I have about 4 years of experience in the area of family law, which means I've had exposure to how the family law court system previously operated and how the new system has worked since the court merger. Also a bit about Michael Lynch Family Lawyers before we start. We are a team of specialist family lawyers, and the firm celebrated its 25th birthday in 2021. The firm is made up of 13 lawyers, 6 of whom are accredited family law specialists, and we have over 100 years of combined professional experience together. We see private clients and provide confidential and professional advice in all areas of family law. For new clients, we offer a fixed fee and obligation-free consultation to provide that client with the initial critical advice about their situation so they know how to navigate their family law matter. So in terms of what we'll discuss today, I'll touch on a few things. So what has happened with the court merger and how is it going? Has the law changed? What are the new requirements before you go to court? And also, what are the new court processes within the court? So as you all know, there was the court merger on the 1st of September, and as a result, the court system changed considerably. I actually presented a webinar in April of 2021 when the news of the court merger was announced. You can actually see this webinar for more detail on what changes were anticipated and the views about those changes, as well as the different rules that were anticipated as well. Just to recap on the old system, so you can see a comparison, there was previously the Family Court of Australia, which was the more superior court, and there was the Federal Circuit Court of Australia, which dealt with the less complex matters. As there were two different courts dealing with family law matters, there were two sets of legislation and court rules to follow, which often became a bit confusing. There were also slightly different processes and procedures, as well as forms for filing in the court. So the old system caused considerable delay and cost for parties, so this was really the catalyst for a change to be made. From the 1st of September, the Family Court and the Federal Circuit Court merged together to create the Federal Circuit and Family Court of Australia. So there is one set of harmonised court rules to follow, which is helpful, and it's called the Federal Circuit and Family Court of Australia, the Family Law Rules of 2021. So there is a Division 1 of the court, which hears only family law matters, but it deals with the more complex matters. I'll go through how matters are allocated to different divisions later on. There is also Division 2, which hears family and general federal law matters, and it deals with the less complex family law matters. So the court created, helpfully, a central practice direction for family law case management. We have used this religiously since it was released, as it sets out various processes, procedures, and rules for practitioners particularly. There are also various other practice directions which relate to specific lists of the new court or areas of law. Some examples are appeals, divorce, bankruptcy proceedings, child support issues, financial proceedings, parenting proceedings, etc. These can all be helpfully found on the court website, and they're downloadable as PDFs. So essentially, there is a core principle of the central practice direction, which states that the overarching purpose to be achieved is to facilitate the just resolution of matters, one, according to law, and two, as quickly, inexpensively, and efficiently as possible. So the overarching purpose includes the following objectives. So the just resolution and determination of matters, the efficient use of judicial and administrative resources, the efficient disposal of the court's overall caseload, because previously there was a huge backload in the court system. The resolution of disputes at a cost and by a process that is proportionate to the importance and complexity of the issues in dispute, and also the timely disposal of matters in the court system as well. The practice direction states that the central practice direction and the rules must be interpreted and applied in a way that best promotes the court's overarching purpose, but also prioritising the children's best interests. So essentially, the court is focused on parties reaching their own agreement where possible and without the court's intervention. Where the court's intervention is required, though, the court is really focused on, with this case management pathway, on ensuring matters are progressing through the court system a lot more quickly and as cost effectively as possible for parties. I actually watched a webinar last week, which was hosted by some senior judicial registrars of the court, and they emphasised the court's focus on dispute resolution and actually encouraged practitioners to be giving their clients that difficult and serious advice at a very early stage in relation to both financial costs as well as emotional costs of commencing court proceedings. Now that the court system is aimed at progressing matters more quickly, we can't just rely on the delay in the court system as a deterrent to commence proceedings, but we're just focusing on the financial and emotional costs as well. So there are some steps parties need to go through before they commence court proceedings, and it's known as the pre-action procedures. So the court practice direction states that prior to commencing proceedings, parties need to firstly comply with these pre-action procedures, which relates to both financial and parenting matters, and take genuine steps to resolve their issues in dispute prior to commencing court proceedings, unless it is unsafe to do so, of course, or if a relevant exemption applies. So there may be serious consequences for non-compliance with these pre-action procedures, which the court has been very vocal about, which can include cost penalties or a stay of the proceedings pending compliance with those pre-action procedures. So the court has set out some objectives of these pre-action procedures, which are essentially to encourage early and full disclosure, to provide parties with a process to avoid legal action by reaching their own settlement, to resolve matters quickly and limit costs, to ensure the efficient management of court proceedings if they are required, to encourage parties to seek only orders that are reasonably achievable on the evidence, and to give effect to the overarching purpose of family law practice. So there are some exemptions, of course, for complying with pre-action procedures. For example, if the matter is urgent, which I'll go through later on, and if there are allegations of family violence or risk of family violence, as well as a risk of child abuse as well. The court has helpfully released 2 court brochures in relation to these pre-action procedures in relation to parenting and property matters, which actually provide parties and practitioners a step-by-step guide as to what they need to do prior to commencing court proceedings. So there are slightly different steps you need to take for parenting and property matters, but they are relatively similar. So you'll see the steps on the slides before you, but just in summary, the pre-action procedures involve, I guess, inviting the other party to participate in dispute resolution, which is a new process for property matters, attending that dispute resolution if possible, and then if no agreement is reached, providing the other party with a written notice of your intention to start a proceeding, and that's called a notice of intention. The other party must be given the opportunity to respond to that notice of intention, and you need to give them a 14-day time frame to do so. The parties can only file an application in the court if they've exhausted their avenues of reaching their own agreement through the pre-action procedures, and they need to be able to show that these attempts have been made. So the pre-action procedures have been helpful where parties have been able to negotiate through some correspondence and then attend a mediation if need be. In saying that, it has actually been difficult for us practitioners where you're faced with for example, a self-represented litigant who hasn't received any legal advice, and you're sending them letters about disclosure and valuations, and you're getting no response. Because now we have to give our clients that advice that we need to actually invite them to mediation, even when we might not know what the matrimonial pool is or the property pool is. And then even if we don't receive a response to that, we still need to send them this notice of intention, which needs to be quite comprehensive, and it needs to set out the issues in dispute between the parties, a genuine offer to resolve those issues in dispute, and then the orders you're going to seek if you go to court, which actually shows your case quite early on. So if it's great, and if the parties respond to this notice, and it can help some negotiations. But if you don't receive a response to that, then the parties still need to go to the effort and incur the cost of solicitors preparing their court material after all of that has occurred. So, of course, the pre-action procedures can result in parties reaching agreement, which is the ultimate goal of the court. They can still document their agreement in the form of a consent order as one option, and they will still file an application for consent orders and minutes of consent orders with the court online via the Commonwealth Courts portal. So it's still the same process. However, now once the applicant files those documents online, they're actually allocated a date for a consent orders hearing, which is an in-chambers hearing where the court just sits down and considers the consent orders. So we've seen that this date can be listed for weeks into the future, and then the outcome is released on the portal after that date. So with the new system, that seems to be how it's working at the moment, but there has been some considerable delays and some teething issues with this consent orders hearing and the release of orders. I've had colleagues actually say that they've had delays of upwards of 8 weeks to actually receive some concealed consent orders from the court, which is huge, and clients are very stressed and obviously anxious to get their matter completely resolved, and they can't really do that without having those sealed orders. I attended the webinar, a different webinar as well, and we spoke about the delays, and the court has actually said that Brisbane was affected quite considerably, and it seems to be alleviated at this point. The time frame for consent orders to be approved is about 3 to 6 weeks at the moment. In saying that, I actually filed some consent orders 2 weeks ago, and the court actually released the sealed orders the following week. So it wasn't even 1 full week and we received the orders. So I'm thinking it really does depend on the registrar considering the orders and their respective caseload as to how quickly you're getting orders back. With this new court system, there's been different registrars in registries all over Australia considering consent orders, and not just registrars in Brisbane. So that impacts things as well. I guess one other issue we have experienced with consent orders and the different registrars is they have different ways of addressing consent orders and issues that might be in them. For example, we have had colleagues at our firm submit consent orders in the same way that they've submitted them for years with the same types of clauses, and now the new registrars are actually requisitioning these orders, essentially rejecting them, saying that they need more information or clarification on particular issues. It can be something as simple as including the word nominal as the value for furniture instead of including a value for the furniture. So we're actually telling clients that we're being very pedantic in preparing our consent orders at the moment, because we're saying we don't want them to be requisitioned by the court, because that can cause further delay in having them actually approved. So we're actually taking the time because we don't know what different registrars are going to be doing with orders. So that's one other issue we've seen at the moment, and I'm sure it will change as time goes on. So if consent orders aren't reached, parties do have that option of commencing court proceedings if they have complied with those pre-action procedures. They, of course, do need to show the court through what's called a genuine step certificate that they have complied with the pre-action procedures and that they've taken the genuine steps to resolve the issue, and or if they can show a basis for a claim for an exemption from compliance with those issues. So in addition to filing the genuine step certificate, parties obviously do need to file additional court documents. Some have remained the same from before the court merger, but there are some new ones. So for financial matters, parties need to file the usual initiating application or response if you're responding, a financial statement, an affidavit, which actually only needs to be filed if you're seeking interim orders, and a financial questionnaire. So the financial questionnaire is actually a new document and it's quite comprehensive. So it actually goes through a lot of information that you would otherwise put in your affidavit. So given affidavits are only needed if you're seeking interim orders, we're actually saying to clients that if you just want to get your foot in the door and you don't want to incur that additional cost of preparing an affidavit, then we won't seek interim orders, which are essentially procedural in nature anyway, except if you're wanting, a substantive order such as a sale of a house on an urgent basis or something. So that's what we've seen happen at the moment for property matters. Of course, if you're filing parenting as well, you will need to file that affidavit, which is limited to 10 pages and 5 annexures for Division 2 of the court. So otherwise for parenting matters, you have the initiating application or response if you're responding, the notice of child abuse, family violence or risk, a copy of the dispute resolution certificate, and also the new document, which is a parenting questionnaire. So similar to the property questionnaire, it's quite comprehensive and it goes through a lot of issues which are contained in your affidavit material. I've heard registrars say that they are really happy if solicitors can prepare a comprehensive but succinct affidavit covering off all of the issues in that one document, but they've created this parenting questionnaire as a backup in case all of the issues aren't covered in the affidavit, and particularly for self-represented litigants, because the parenting questionnaire is quite straightforward. So I guess the practice direction clearly states that other than in urgent circumstances and subject to any safety concerns, no application for final or interim orders should be filed without appropriate notice being given to the respondent of the intended contents of the application, and without those genuine steps being taken to avoid the need for the application to be actually filed. So that's where the pre-action procedures and the notice of intention comes into play. The court has said that parties and lawyers are expected to approach proceedings in a manner directed towards identifying issues in dispute on one hand and ascertaining the most effective, efficient method of resolution or termination of that matter. So this includes giving proper consideration to those issues in dispute at an early stage, complying with your obligation to provide full and frank disclosure, which is still absent from many matters, considering the rules as well in terms of your disclosure obligations, engaging in productive and resolution-focused communication with other parties, making appropriate admissions where applicable, and pressing only issues that are involve genuine significance for the parties. So ambit claims should be avoided, and aggressive and unnecessarily adversarial conduct won't be tolerated by the courts, it seems. So at all stages in the proceedings, the court has said that parties must avoid filing evidence that is unnecessarily lengthy or only of limited relevance to the issues genuinely in dispute. The court only wants to read, information about what are the issues in dispute, which can actually be quite a number of issues if parties aren't complying with those pre-action procedures. So parties should also limit the number of witnesses they're relying on as well, and focus on witnesses which support those issues which they're trying to prove or disprove. So in terms of the signing and witnessing requirements for court documents, the court has helpfully released a special measures practice direction in relation to COVID-19, which is available on their court website as well. It provides information in relation to various issues, including the filing of documents electronically and by email if required, the inspection of subpoena documents, and signing documents and affidavits. So the court will accept documents for filing that have been signed electronically by the deponent or the legal representative on record, where there's an electronic signature or if their signature's actually been typed on the document as well. The exception to this is the document called Affidavit for E-Filing Application, in brackets divorce, which is used to commence divorce proceedings. As standard practice, I get my clients for divorce matters to actually physically sign and have witnessed their signatures on affidavits for divorce matters, just to avoid the court requiring that in the future as well. The court does encourage, where possible, to have their parties to have their documents witnessed electronically via video, which is also set out in that practice direction. If a document isn't witnessed, so we need to advise clients that they may be required to affirm or swear the contents of that document are true and correct if the judicial officer requests it. So it's essentially just making sure clients know that the document still needs to be correct, even if they aren't having their signature witnessed. So then in terms of filing and service of documents, so the usual rules in relation to service apply, being that the initiating application and any other document must be served on each party to the proceedings as soon as reasonably practicable after filing, and no less than the time, if any, specified in the court rules. So the issue with this is, with the new system, is that first court events are actually being listed so quickly, and sometimes within, say, 1 month of the filing date, which was unheard of previously. So this doesn't actually provide the respondent with a 28-day time frame, which was the usual time frame, to respond to the initiating application. So we're faced with, rushing around the week before, or 2 weeks before the court event to have a response material filed, just so that you can go to that first court event and the registrar has all the information it needs. So we have seen registrars adjourn first court events where a party hasn't had enough time, but the court generally expects responses to be filed before that first court event to avoid delay. This does particularly disadvantage self-represented litigants who haven't engaged a solicitor previously, and they need to make an appointment to see a solicitor, who then needs to quickly wrap their head around the file and prepare some response material. So in terms of urgency and filing an application on an urgent basis, you can seek an urgent interim hearing from the court through your initiating application. Those applications will be assessed by a judicial registrar at the time of filing. If that matter is accepted as urgent, an interim hearing date will be given at the earliest possible time, having regard to those issues in dispute, including the extent of the urgency and considerations of procedural fairness as well. So following an urgent hearing, matters will be referred to FDR where appropriate, and will otherwise be listed in accordance with that case management pathway, which I'll go through shortly. So I mentioned earlier that there is this triage and assessment of matters once cases are filed in the court. So with the court merger, there is that one single point of entry into the court system, which is the Division 2 of the court. So a case can be assessed at any time throughout proceedings by a national assessment team for consideration of various factors, including whether the matter is one of a small number of cases which should be in a specialist list, the suitability of the matter for inclusion in a specialist list as well, any special procedures which are required as a result of any risk associated with family violence identified in that application, whether all the pre-action procedures have been complied with as well, and whether in parenting proceedings the requirements of Section 60I of the Family Law Act have been complied with, which is where parties attend the family dispute resolution prior to commencing court proceedings. So the appropriate division for the hearing of a matter will be considered at a few different stages. So firstly, as a part of that initial triage and assessment process of the court, where a small number of cases will be transferred to Division 1 immediately. The second stage is at a compliance and readiness hearing, which I'll go through shortly, and the court will consider what remaining issues that are in dispute, which might necessitate the matter for transfer to Division 1. And the court can do whatever it likes essentially and transfer a matter to Division 1 at any stage as considered appropriate by the court. So any matter in relation to which Division 1 of the court holds exclusive jurisdiction shall be transferred to that division upon filing, as I said earlier, without the need for an application to be made for transfer to Division 1. This includes matters involving, 1, an exercise of jurisdiction pursuant to section 133(7)(c) of the Corporations Act, or an application made pursuant to the Family Law Child Abduction Convention regulations, which is the Hague matters, where you see under the Hague Convention. So determination of the appropriate division for the hearing of a matter will be made at the court's discretion, having regard to a few factors, the Family Law Act and the rules, of course, any assessment made by that national assessment team as well, and any submissions made by the parties. So the factors relevant to the assessment of the appropriate division for the hearing of the matter include various factors, mainly the complexity of the legal, factual or jurisdictional issues involved in the matter, whether the case involves some international aspects, whether there's multiple parties, whether there are some experts in the matter, and if there's multiple experts, the likely length of the case and how many days are needed for the trial to proceed. For a parenting matter in particular, whether the case involves some serious criminal conduct, or in relation to a financial proceeding where there's some complex asset structures, complex valuation issues, etc. So there are various factors the court considers when seeing if a matter is appropriate for Division 1 of the court instead of Division 2, which is the standard division. So unless otherwise ordered, a matter transferred to Division 1 will retain the same priority as it had in the former division that it was transferred from. So the court has provided a case management pathway model, helpfully, which shows how matters are going to progress through this court system. You'll see that there are different standard court events that the court has included. The court has referred to judicial registrars and senior judicial registrars as leading this case management pathway until the matter is referred to the compliance and readiness hearing around the 6-month mark of the court proceedings. So there have been many new appointments of registrars, which has made sure that matters are moving through the court system more quickly. The court has said that the time frame from filing to a trial is around 12 months at the moment. This is quite an improvement on the previous system where parties could be waiting between 12 months to 2 years plus for a final hearing, and even longer for the judgment to actually be delivered. So I'll go through the different court events briefly shortly, but just to let everyone know as well that before a first court event now, parties are required to ensure that they've not only complied with pre-action procedures to get into court, but also complied with their duty to provide disclosure under the court rules. So this is particularly relevant for property matters, but it's also relevant for parenting, and the rules set out what documents and information needs to be disclosed before that first court event. So before each event as well, solicitors are required to actually give their clients and file with the court and serve on the other side a document called a cost notice, which sets out the costs incurred by that client to date, whether the party is in receipt of legal aid funding, the third party costs incurred and anticipated, and the anticipated legal costs for the future as well. So the court has actually said that they look at these cost notices quite closely, and where the issues in the matter are disproportionate to the costs, they can make notations about this, which solicitors definitely want to avoid. So you'll see that the listing pathway involves some standard court events, the first being the first court event, which is listed where possible on a date between 1 and 2 months from the date of the commencement of a proceeding, which I've seen is actually accurate at the moment. The second major court event is an interim hearing where it is required, and it will be listed at an appropriate time, having regard to the urgency of the issues, preparation of any expert reports, or other evidence as well. There is a dispute resolution event, such as a mediation, conciliation conference, or a family dispute resolution for parenting matters as appropriate, which the court says should be completed either within the court or externally as early as possible, and no later than 5 months after the commencement of the proceeding. So for matters which remain unresolved after that dispute resolution event and aren't allocated to a fast track hearing list, there will be a compliance and readiness hearing, which I referred to earlier, around the 6-month mark. The parties will be referred to a judge after this point, and they will consider whether the matter needs to be listed for a trial management hearing as well before the actual trial. As I said, the aim is to have parties proceed through a trial at least or even earlier than 12 months from the date the proceedings were commenced. The court has also said that they aim to have judgments delivered within 3 months of completion of a trial. This is really a good incentive for the court, because previously I've had colleagues say that they've waited 3 years plus for a judgment to be delivered, which actually puts a hold on parties' lives, and they don't know what the determination of their trial is for quite some time. So in addition to this court pathway, the court may, in circumstances of urgency, or if at any time the court considers it appropriate to do so, make directions as appropriate, list the matter for a further hearing, conference, or a call over, determine that one or more of the events in that case management pathway aren't appropriate and should be dispensed with, or they can otherwise depart from the process as outlined in the central practice direction if it suits the circumstances of that case. So I'll go through a couple of the court events in a bit more detail, which we've actually experienced from this new court system so far. So the first court event, it's primarily procedural in nature, and it is heard by the judicial registrar. The court considers at this point what steps are required to progress the matter. So for parenting matters, the court considers, among other things, whether a family report or a child impact report is appropriate, whether an independent children's lawyer should be appointed, and whether some dispute resolution is appropriate for this matter. They'll consider what has occurred in the past as well, so it really is assessed on a case-by-case basis. So a new report which has been created is called a child impact report. For those of you who know reference to the Section 11F report, this child impact report replaces that, and it's actually made pursuant to Section 62G of the Family Law Act. The report is aimed at providing the court with information at an early stage of the impact of the proceedings on the child. It isn't a full family report which can be obtained privately, and the child impact report can be obtained through the court. There are delays, however, I've seen recently of say 6 months to actually obtain that child impact report, which can delay proceedings. So hopefully there will be an improvement in that respect in the court system shortly. So for property matters at the first court event, the court will look at whether disclosure has been complied with, if there's any independent valuations which need to be obtained, if dispute resolution is required in the form of a further mediation or conciliation conference, etc. So sometimes a second court event is required even though it's not listed on the standard case management pathway. This is particularly the case where, for example, a respondent doesn't appear at that first court event, or filed material, or both of those issues. I've actually had one recently where the registrar actually had availability 1 week after that first court event for a second court event, which was great for us because our client really wanted to progress to an interim hearing as quickly as possible. If in a webinar I watched actually recently, the senior judicial registrars have said that they don't expect parties to have engaged a barrister for the first court event, the second court event, or even dispute resolution, given the procedural nature of those court events now. So they aren't an interim hearing, which could have occurred in the old system. You just didn't know what issues were going to be determined that day. So sometimes dispute resolution can be ordered before a matter is listed for an interim hearing, which is the next major court event. However, it does depend on the circumstances of the case and if dispute resolution has been attempted previously. There is also now a court-based dispute resolution system for both property and parenting matters, which is helpful. So in terms of the next major court event being that interim hearing, it's actually run by a senior judicial registrar who has different powers compared with the judicial registrar. I'll go through those as well shortly. So previously, parties in the old system would be listed for an interim hearing, and they would turn up, have counsel ready, and then the judge would say they didn't have time to hear the matter. This would be a waste of money and time for parties and their legal representatives. Now, the court has said parties should be properly prepared to run their case at an interim hearing. Parties shouldn't assume then that an adjournment will be granted on the day, and the court actually has said that cost consequences can follow if you aren't ready to proceed on that day, given particularly their emphasis on ensuring matters are progressing through the court system quickly. So in terms of some impediments to interim hearings proceeding effectively, the court has said there are various issues, including the absence of a clear articulation of issues in dispute, the relief sought, the evidence, etc. A thorough review of the material and subpoena documents that might have been requested, evidence of a child's views in the form of a report, the absence of expert evidence to assist with complex issues, some drug test results which would have been requested, which are necessary for the determination of interim issues, full disclosure, and for example, if you're seeking costs at that interim hearing, the court expects you to have looked at the scale costs in terms of quantifying that cost for the court at that interim hearing. So after an interim hearing, procedural orders and directions can be made for referral to specialist lists, transfer between different divisions, as I've spoken about, directions in relation to obtaining a child impact report or a section 62G report, which we spoke about, attendance at a dispute resolution event, of course, and orders or directions as required, including in relation to a compliance and readiness hearing, making sure it's within that 6-month period. So there are some particular issues which senior judicial registrars don't have delegated powers to determine. These are still being ironed out by the court at the moment. However, they generally include applications for granting leave out of time, summary dismissal in certain circumstances, to actually add a party to a proceeding, some child support issues, third-party injunctions, and some adult child maintenance as well, just to name a few of those. So I have spoken about some specialist lists which were a part of the previous system, but there is a new one as well. So the court is and has taken a meaningful response to this from family violence and risk, and the overarching purpose is evident in every effort to develop effective case management strategies for those matters. So these specialist lists include the Pilot Lighthouse Project, or the EVITS list, which is where there's some evidence of risk and domestic violence. This was commenced prior to the court merger and has proven to be quite effective for these matters and ensuring some safety concerns are alleviated. There is also a new major complex financial proceedings list. There is the list called the Priority Pools under $500,000, which was introduced a few years ago. There's a new list called the National Contravention List, dealing only with contravention issues, ensuring that those issues are dealt with by the court as quickly as possible. And also the National COVID-19 List, which has been a hot topic given the COVID-19 restrictions and child vaccinations and those types of things. So that was introduced prior to the court merger, but I will just delve into that a little bit because the court has released some decisions quite recently in relation to vaccinations in particular. So the court does recognise that the COVID-19 pandemic has triggered an escalation and increase in domestic and family violence, financial hardship, and family law disputes generally. They have created this fast-track specialist list, which operates both in Division 1 and 2, and it is overseen directly by the Chief Justice of the court. The list is designed to hear discrete and priority applications. It isn't a means of backdooring the usual case management pathway which we spoke about, or bypassing that need to make a genuine effort to attempt to resolve that issue. So parties essentially aren't able to jump the queue just by trying to get in the court system through this COVID-19 list. The court's quite aware of this. So the list is quite resolution focused. Registrars have said that there have been about 740 matters that have sought to be included in this list, and 82% have been accepted. So, and matters have helpfully been given a date for a hearing within 3 to 7 days of filing, which is quite massive. So, in terms of being included in the COVID-19 list, the application must be filed as a direct result or with significant connection with COVID-19 pandemic. It needs to be urgent or priority in nature, which needs to be shown through your material. You need to have a supporting affidavit. And the matter also needs to, of course, be capable of being dealt with via electronic means. You need to also show that there have been attempts to resolve that issue. So matters which generally form part of the COVID-19 list include family violence matters, suspension of parenting orders, vaccination disputes, which I will go through, some different medical related circumstances as well. There's also been, which isn't quite common at the moment, but was common, some travel related arrangements and border restriction issues where, for example, parties, the mother and the child lived in Queensland and dad was living in New South Wales. So making sure that time can be facilitated where possible. There was also some supervised contact issues, for example, where the contact centre, if time was facilitated through that centre and if it was closed as well. There have been some urgent financial and maintenance issues in relation to COVID-19 as well, and also failure to resume a party's time in accordance with orders if there had to have been a suspension of time for certain reasons. So for the purposes of filing an application in this COVID-19 list, you can send documents to an email instead of filing online. Parties are also required to file particular documents, including a template cover letter for urgency issues, that initiating application, a COVID-19 template affidavit, which is no more than 6 pages long. You also need to file the usual documents for parenting and financial matters, as we spoke about earlier. So we've seen the matters forming part of this list are generally either vaccination related or non-vaccination related. The court has been clear in those matters that children being vaccinated against COVID-19, and that it's really up to the parent opposing that application and vaccination to provide independent and compelling evidence to show why the vaccination should not be administered. The court will consider reports from different medical professionals and public health advice supporting the opposing parent's view, but they do need evidence. You can't just say, and they've said it has occurred, that the government's lying to us, the child shouldn't be vaccinated because that's against my views. You need to have evidence, essentially. So if the court is granting the parent's application to have the vaccination for the child, they're generally taking the approach that that parent should have sole parental responsibility in relation to vaccinations and immunisations to avoid any issues in the future. The court has said if they were to say grant that party the ability to have the child vaccinated, Then there could be issues if there are follow-up appointments and the other party is refusing to allow those appointments to occur. And then you would be back in the court system trying to get that permission. So if the party has sole parental responsibility in relation to those issues, they can make the decisions in relation to that. So there have been series of published cases released. So I'd encourage you to have a look at those if you're interested in more information. So in terms of the court system that has emerged, we've found that once parties enter into the court system, they are generally being allocated court dates quite quickly, and their matters are progressing towards interim and final hearings more quickly. In saying that, as I've discussed, there have been some additional hurdles for parties to get over before being able to commence court proceedings, particularly for financial matters, which weren't in place before. They need to do these pre-action procedures, including in mediation and the notice of intention before going to court. This can be costly and also time-consuming for parties when they're trying to reach their own resolution. As I said, when you're faced with this difficult self-represented litigant on the other side, or a solicitor who doesn't want to obtain a valuation or provide disclosure, it can be costly and time-consuming as well. So given the court system at the moment and how it is fast-tracked, we as practitioners are feeling quite overwhelmed with the number of clients we're having who are at that stage of complying with the pre-action procedures, and they're actually all ready to commence court proceedings around the same time. So this means essentially, if we're looking at that case management pathway, that they will have multiple matters who are in trial at the same time in 12 months. So that will be very overwhelming for practitioners, and trying to obviously give clients that same attention as required, but also making sure we're covering all of our clients as well. So applicants' costs are also being increased in the form of us needing to give them additional advice on these different procedures, but also we do need to give them those cost notices ahead of each court event, which can be costly. You need to update these cost notices and also send them to the other side. Of course, we do need to give clients notice about their costs anyway, but it's just that extra step we need to make sure it's in an appropriate form and filed with the court as well. So the new court system is certainly an improvement on the old system, and once some teething issues are resolved, it definitely should benefit those parties who are just struggling to reach an agreement with the self-represented litigant or the other side, and want to achieve a quick and final resolution of their matter. So thank you for joining me this afternoon for this webinar. We thought it was a great opportunity to explain the effect of the court merger and how it has been operating, and hopefully answer any queries you may have had after the merger took effect last year. If you have any specific questions regarding the court merger or what I've raised today, please contact our office via email. Of course, I couldn't cover all of the new aspects, but just the major milestones which have been introduced for parties to follow. We'll send around a feedback survey after this webinar, which you can use to specify any questions or comments you have. But we do really appreciate any feedback you have for us. If you're interested in or would like to know more about specific areas of family law, we do have multiple webinars and articles on our website as well. They cover a range of topics, including property settlement, parenting matters, relocation issues, and also specific webinars for you accountants and counsellors as well. We do have 2 upcoming webinars on the 10th and 30th of May in relation to family law generally, as well as property settlements, which I'm sure will be very informative for you. If you have any suggestions about topics you'd like to see covered in future webinars, we'd love to hear from you as well. Otherwise, as always, if your clients have gone through a relationship breakdown or marriage breakdown and would like some specialist advice from us, we're happy to speak to them. So thank you again, and I hope you've enjoyed today's webinar.